Hi, it's Shan Wu with an Undercolor of Law hot take about the Stormy Daniels testimony. Sometimes in a really big trial, there's a moment that seems to symbolize something about where we are as a society. And I think Stormy Daniels' testimony is such a moment. It's really a warning tale about using the end justifies the means philosophy in law and in life. Now, that saying is attributed to the Italian Renaissance philosopher Niccolo Machiavelli, the guy who wrote The Prince. But actually, fact check, Machiavelli never actually said those words. The closest he got to it is a quote from his work, The Discourses, and that quote is translated along the lines of, "For although the act condemns the doer, the end may justify him." So how does that relate to the Stormy Daniels testimony in the New York election interference case against Trump? So a quick summary, recall, the case is based on the idea that Trump falsified business records to cover up payments made to Stormy Daniels as part of a deal for her to stay silent. And that the reason they wanted her to stay silent was to make sure that damaging information didn't come out that would hurt his election chances. Again, there's nothing wrong with paying someone to keep quiet. It happens all the time. The crime is having falsified the business records to make them look like something they weren't. They were actually a reimbursement to his lawyer, Michael Cohen, and they tried to make it look like it was invoices. And step two, they did that to help the election to interfere with that, and they didn't disclose that. The reason they're so worried was Stormy Daniels would have come out with this story on the heels of the access to the famous Access Hollywood tape, which has Trump on tape bragging about grabbing women's genitals while they're not consenting to it, saying he can do anything, would have been very negative, maybe even fatal to his campaign. So how does this relate to the end justify the means? Well, let's take a look at what was happening with her testimony and with the cross-examination approach adopted by Trump's legal teams. And really, what are the consequences for them as a matter of legal strategy and what it says about the bigger picture of our times? So in the direct testimony, Stormy Daniels, who's an actress and a director, gave solid prosecution testimony. She came across as a human being who seemed rather nervous. She was talking kind of too fast. She was asked to slow down a couple of times. She made some jokes that she laughed at herself. That generally is the classic signs of a witness who is very nervous. But her testimony gave the prosecution what it needed about the evidence supporting the allegation that there had been a sexual encounter between her and Trump. And according to the prosecution's theory, that is what Trump was worried about coming out. That's what he was trying to cover up. Now, there's been a lot of criticism about the prosecution putting forth too many details about the encounter. People call it salacious, graphic. But one thing that Judge Merchan has pointed out when he denied the second attempt at a mistrial by the defense team is that the defense themselves, in their opening statement, made the allegation that this was all made up. That's called opening the door. By putting forth that allegation, it gave the prosecution permission legally, and in fact necessitated them legally, having to put out evidence that it did happen, because part of the defense is that it didn't happen. Now, it's kind of a dumb defense, because the real issue here isn't whether there was a sexual encounter. The real issue is how did they try to cover it up? So the defense didn't have to get into all that, but I'm guessing that maybe somebody's client, former President Trump, really wanted them to get into that and really go after Stormy Daniels. Now, her testimony was, of course, vulnerable, remains vulnerable to the fact that she can't know all the issues involved with the fabrication or falsification of the business records. She's not an accountant. She wasn't doing that part. Nor would she be able to say that the payment had been made specifically to help Trump's election. That wasn't happening at that time. All that happened at the time was she had this alleged encounter, and that later she was offered money not to talk about it. If the defense had just focused on that, as many people have said, that would have been effective, smart, and maybe pretty effective in terms of opening up, there's this big hole in the nexus of the prosecution's case. But that's not what happened. Instead, the only female lead attorney on Trump's team, Susan Nechles, was chosen to do the cross-examination, probably with some notion that the optics looks better if it's a female attorney cross-examining a female witness. And like the rest of Trump's team, Nechles, previous to this, like many of Trump's lawyers, had a very strong reputation. She was an experienced trial lawyer, well-known defense lawyer, and a former assistant district attorney, a state prosecutor, who had turned to criminal defense. But from the very opening of her cross-examination, her tactics and strategy indicated that either that reputation was completely unjustified, or she had chosen to disregard her skills, her training, and her usual legal acumen in order to achieve the end of pleasing her client, the former president. Her opening question to Stormy Daniels was comically bad. She asked Daniels, quote, "You've rehearsed all this. Your testimony is rehearsed." Now, that's the kind of question that a high school mock trial student tries in their first effort at cross-examination, thinking they're going to sound like Perry Mason. Daniels easily fielded that by simply saying no. And then Nechles got into a word salad colloquy where she tried to point out there's a difference between doing mock cross-examination versus rehearsal. That went on for a while, and it pretty much went nowhere before Nechles moved to the next aspects of her attack on Daniels. Now, one thing you want to do in cross-examination is you don't want to hit a home run, so to speak. You don't want to put out this huge question that, if the witness answered the right way, would help your case enormously. Why don't you want to do that? Because that's not what witnesses do. You don't say to the witness, "You're actually lying, aren't you?" And the witness says, "Yes, I am." That just does not happen. What you want to do is to make very specific points, get some admissions, agreements from the witness, so that you can use those in your summation to the jury to put together the theory of your defense. So instead of doing that, though, Nechles has started out with this general attack about the idea that her testimony has been rehearsed. She asked her, "Didn't you get coached by your lawyers?" basically. One of the problems with that question, why it's so comical, is that in every case, the judge instructs the jury that there is nothing wrong with witnesses being prepared by lawyers. In fact, part of that instruction is the lawyers would not be doing their job not to prepare the witnesses, just throwing them on cold and seeing what the heck they're going to say when they get up there. So by the second day of the cross-examination, Daniels had actually picked up on this point and made that point to Nechles, saying that there is nothing wrong with witnesses being prepped. So you know you're doing a bad job on cross when the person you're questioning is basically citing the law back to you. One thing for an untrained person to try to pretend to cite the law, it's another when the jury is going to hear from the judge the very same legal point that the witness is making. So Nechles continued to ratchet up this very aggressive style of questioning. And one could say by the end of the second day that the style was definitely a bullying kind of style, which of course makes a lot of sense given who her client is. Also, perhaps a reason Nechles was being so aggressive was the observation of CNN reporter Paula Reed, who noticed that during the direct testimony of Stormy Daniels, Trump kept literally prodding Nechles physically, tapping her on the arm, apparently in an effort to get her to object. Now, one of the complaints of the Trump defense team has been that the prosecution was allowed to bring out too many details about the sexual encounter. And as we just discussed, one of the reasons that the judge allowed them to bring that out was because they had claimed it never happened. So the judge is going to let the prosecution put out testimony from Daniels that would allow the jury to ascertain, well, is this credible? Do we believe her or not? The problem with the Trump team complaining about this, asking for mistrials not once but twice, is obviously they know what Daniels is going to testify about, and they would have previously litigated this with the judge to develop the kind of parameters for what is allowed to come out when she testifies. So that was pretty much a baseless request for the mistrial, and Judge Juan Marchand quickly dismissed it. So given that, remember they're arguing that this was really bad, it was wrong for it to come out in front of the jury to talk about the sexual encounter, theory being this is so prejudicial to Trump that the jury might just convict him because they think he's a bad guy. Given that concern, you would think that they would not want to highlight those details anymore. Now, keep in mind one other thing that some commentators have noted, which is there's a lot of relatively ministerial kind of testimony about who kept the checks, how can you authenticate the checks. A lot of those would normally be stipulated to save time because no one's really going to fight about is this the authentic check or not. If they were really worried about Stormy Daniels' testimony about the details of the sexual encounter, they could have stipulated to that. They could have said, okay, they had this encounter. That doesn't matter here. We're only talking about, was there a cover-up? Did Trump orchestrate the cover-up in order to interfere with the election? But they didn't. They wanted to take on whether Daniels was telling the truth or not. So if you want to take that on, then you can't really also complain about the fact that she's being asked to testify about her memory, having her memory tested on cross-examination. So for that first day and for the second day, the cross-examination by Trump's lawyer Nechles chose to really lean into the sexual aspects of the case. Nechles kept on asking Daniels about how many adult films she had been in, and she also made the point when Daniels had testified that she had been shocked when she came out and Trump was laying on the bed. He used to be dressed, I guess, in business apparel, and now he was like laying on the bed in sort of Hugh Hefner kind of style. And Nechles even said to her, you've been in all these adult films, what are you shocked about? Obviously an attempt to make the point that because Daniels had acted in adult films that involve sex, that therefore she didn't have any right to complain about Trump coming on to her this way. And there's a strong flavor in Daniels' testimony that there's a sense of a power imbalance, that she felt uncomfortable about the idea that Trump's a large guy, he's powerful, he's rich, and that his bodyguard was just outside the suite door. All that gives this a flavor of it being somewhat predatory towards her, even though she was very clear about the fact that this was not a non-consensual attack of any kind. Well, one of the other aspects that Nechles tried to bring out was she used this bizarre line of questioning with Daniels that said to her that, don't your films involve sexual encounters? And that those films are work of fiction. And then asked her, you're very good and used to fabricating works of fiction involving sexual encounters. Seems a very odd kind of theory, but Nechles actually asked that question. She tried it out on Daniels. And you can take a look at some of the people in court. They recorded that particular dialogue that went on between them. So besides the fact that Daniels slam dunked the question on Nechles' head, consider what the real theory is. What's the logic Nechles was trying to get across? The extension of this theory is that no actor could ever provide truthful testimony in court because in their profession, they use scripts. Anybody who has to memorize a script ever must always be untrustworthy. Now, maybe that'll work with someone on the jury. I kind of doubt it. It just defies common sense. Nechles also very much wanted to show that Stormy Daniels was very biased against Trump. And that's a standard cross-examination technique to use. You want to show that maybe the witness is embellishing, making up things, not being truthful because they have an axe to grind. They're trying to get the defendant in trouble. That's fine. But using it here makes very little sense because the issue is whether Daniels' testimony about historical facts that happened a long time ago are accurate. And at that time, she had no bias against Trump. It was some 18 years ago when she met him and had that sexual encounter with him. So when Nechles is trying out the standard idea of you hate Trump, his bias here, she's ignoring the fact that the only reason Daniels has for hating Trump is all the things that have happened since then involving what Trump's saying about her, saying she's lying, calling her names like horseface, saying that she's like a toilet. So yeah, obviously she hates him now, but the bias now doesn't affect what happened at the time that it happened. Daniels was very honest. She even agreed that she'd like to see Trump in jail. She also admitted that there was a civil suit that she lost against Trump, which was the idea of her now disgraced attorney, Michael Avenatti. They filed a defamation suit and lost. And Daniels has said, she refuses to pay this large amount of money to Trump, claiming, she'd rather go to jail than have to pay him. It's very honest, but nonetheless, some legal analysts seem to think that that admission on cross was a huge victory for Nechles. So take a listen to my colleague, Ellie Honig, and I'll talk with you on the other side.
Tell room. But the cross exam, boy, her responses were disastrous. I mean, do you hate Donald Trump? Yes, of course she does. That's a big deal. When the witness hates the person whose liberty is at stake, that's a big damn deal. And she's putting out tweets, fantasizing about him being in jail. That really undermines the credibility. The fact that she owes him $500,000, she, by order of a court, owes Donald Trump $500,000 and said, I will never pay him. I will defy a court order. The defense is going to say she's willing to defy a court order. Why? She's not willing to respect an order of a judge. Why is she going to respect this oath she took? So I thought it went quite poorly on cross-exam. At the end of direct...
Okay, Ellie's reaction to me seems a little bit out of left field, because he actually seems to be suggesting that he would have wanted Stormy Daniels to be coached if she were his client. That instead of letting her testify truthfully as to what her actual feelings are, what her actual attitude towards Trump's, that she shouldn't be allowed to say those things. Again, while it's true that she is admitting under oath that she is biased against Trump, she doesn't like him, it's got nothing to do with when the events happened. There's not going to be a bias at that time. So all you're left with there would be, well, you hate him, therefore you just made up this whole story about him. Common sense question to the jury, why does she suddenly hate him? Where did that come from? And again, that goes to the past 18 years, all this back and forth, when her story was going to become public, when it became the centerpiece of the Manhattan DA's case, then Trump is attacking her, putting her down. So obviously she hates him at this point. Now, the other issue that arises is her testimony, is her credibility affected by that? And you could argue, okay, now you got to question the way she's telling the story. Is she maybe embellishing it because she dislikes him so much? But it also cuts the other way, which is it humanizes her in the presentation that she has gone through a lot. There was even an incident where she was very worried about her safety. And that is also a cause of her wanting to go public now. She's under subpoena. It's really not her choice. But all the public statements that she's made. And as we've seen in the past, there's good reason to fear for your safety when the former president of the United States is calling you names, saying you're a liar. The supporters may do violence. And he's not just suggesting that it's not true what happened. He's engaging in very specific insults. He's denigrating her, calling her a horse face, referring to her as a toilet, so that she would hate him and be scared of that would certainly be very believable. And ask yourselves, if you were jurors, would it be believable for someone who's been subjected to that to say, oh no, I don't have any bias against him. I'm perfectly fine with that. I have nothing against him. That's the really strained logical conclusion that Ellie would want to make by saying that because she is biased, you can't trust what she's saying. If in these circumstances she said she wasn't biased, that would be questionable in terms of credibility. The other odd thing that Ellie's saying is he seems to believe that because she has a judgment against her in favor of Trump and she doesn't want to pay that judgment, that somehow affects her credibility. Or also that she says, oh, I would like to see him in jail, that affects her credibility. Well, I got news for you. Even if Trump goes to jail, that is not going to relieve her of the civil judgment against her. They've got nothing to do with each other. So that's another problem with that criticism of her. It really seems like it's reaching. Now, here's another very well-respected legal expert talking about her testimony. Take a listen.
Tom, the fact that you've got esteemed, and I think really some pretty critical legal minds, yourself, Ellie, a lot of other people who are so divided on this, doesn't that sort of tell you a jury might be equally divided?
Well, at a minimum, it would tell you there at least could be some jurors who see this more through a pro-Trump lens and didn't think that yesterday was the prosecutor's finest day in the New York case. And of course, all it takes is a single juror or two jurors to create reasonable doubt and hang a jury and deliver the defense a win. In my view, I thought the prosecutors actually went too far yesterday. I don't think it was a good day for the prosecution. I think that a lot of jurors heard this testimony, which no question was sordid. It was salacious. It was not safe for work. But I don't know if it was relevant. And I don't know if the jurors understood why the prosecutor spent hour after hour after hour eliciting all these sordid details from Stormy Daniels on an issue that's
not
peripheral.
Not safe for my mother either, who wrote me double ick after our segment on it.
So Dupree was a high-up official at DOJ with significant and important appellate experience. What that means is his view is all from the appellate perspective. So when you listen to his comments, it's all about how prosecutors went too far. That's an issue for the appeals court. His criticism isn't that the testimony that the jury heard wasn't relevant, because that's all that matters at the trial level. Was it relevant? And it is relevant. Why? Because the judge said it's relevant. It can come in. Dupree's criticism is that on appeal, a appellate court might say the judge blew it. They made an error here. They shouldn't have let this in. Too prejudicial, or it's not relevant. And that might lead to a reversal. Now, that's an appropriate perspective for an appellate lawyer, but it's got nothing to do with whether it's effective right now with the jury or not. It's only relevance that counts at this level. And if you bring up something that's irrelevant, or you're putting it in a way that suggests something that isn't proper, there should be objections, and they may be sustained. And the judge may also admonish you as the lawyer and even tell the jury, disregard that evidence, or don't take that evidence to mean the following. So there's all manner of trying to rein in issues with relevance if something shouldn't come in, or after it's come in, it's being used in the wrong way. But the idea that Dupree is suggesting that this failed effort at a mistrial may cause a reversal just because there's all these details about a sexual encounter, that's really not relevant now for the trial issue. That's just an appellate issue. Dupree, like others, seems to be doing a little bit of pearl clutching about the sexual details, even though the judge himself actually seemed rather puritanical, saying it might be a little bit inappropriate. Other commentators have even taken a position that this was not a sexual assault, so why are these details coming in? Well, here's why they're coming in, besides the fact that Trump's people are saying it didn't happen. It's substantively relevant to think about what is it the prosecutors needed to show that Trump wanted to cover up. What's he worried about? What's he trying to cover up? Why would he be motivated to cover up? So her testimony is telling the jury now what would have come out in 2016 if this hadn't been silenced through paying for it. What would have come out are all the details she's talking about that reflect, like the Access Hollywood tape reflected, what his behavior was, allegedly, what his attitude was towards women. His being misogynistic, sexist, privileged, even rather predatory in the way that Daniels perceived him to be. Him saying to Daniels at one point, because they continued dialogue for quite a while, other visits, other phone calls after this one sexual encounter, because he was allegedly dangling in front of her the idea that she might be someone on The Apprentice, his TV show. And there's this comment that she recounted where he said to her, basically trying to string her along, perhaps wanting another sexual encounter, that he said to her that, oh, I thought you were serious about your career, really serious about trying to get out of the trailer park. That reflects his attitude towards women, his attitude towards her. That's the Donald Trump that his campaign did not want people to see, particularly women voters, back in 2016. And that is what he was successfully able to hide, that part of himself then, by paying for silence from Stormy Daniels, silence from Karen McDougal, silence from the doorman. All of these silences gave Trump the time and the opportunity to become president of the United States. And since that time, there's been a normalization of his behavior. People just aren't shocked about it anymore. And we have lots of people using terms that denigrate Stormy Daniels constantly, like the quote, I don't like, the use of the word porn all the time, porn star. The reason I don't like it, as I've explained before, is it's a term, that's the term that's gratuitous, not the encounters of the details of the sexual encounter. What's gratuitous is throwing around a term which, in the use of it, means that you're putting down the person you're talking about. Add in this kind of filtering notion that a criminal prosecution of a powerful person has to meet some kind of morality test. It has to be prim and proper. We can't talk about things that would be improper in polite society when it comes to prosecuting an important person. That's a bunch of nonsense. When there's a crime, you just present the evidence. That's what they should be treating this as when they're commenting about the case, when they're analyzing it. But there's a whole sort of taint to people's attitude towards the case. Now, remember, I said in the beginning of our discussion that this was a tale about the ends justifying the means. Susan Nechles, well-respected, very skilled attorney, took that approach with the ends she was trying to reach, apparently being satisfying her client. That's why she got rid of the normal means that has served her so well for much of her career, the normal processes, the rather normal morality in choosing your legal strategies. Now, she wasn't alone in this. I mean, there's a parade of other lawyers have done this for Trump. And really, on a bigger and much more profound scale, so has society, so has the political leadership of the Republican Party. To them, Donald Trump's presidency, his power that they want a part of, is very much the ends. That's what they want to achieve. They want to have the benefit of the access to that power to make themselves more powerful, maybe accomplish some of their policy objectives, so they don't care what means they use in order to do that. That's why those means include being willing to support a man with this many criminal charges, who's been twice impeached, a man who insults minorities, revs up violence against people, including Asians, insults non-able people, you name it. He encourages violence against those who he disagrees with. And all of these enablers, all these helpers, want the end result of proximity to power, which gives them power. And that means they're ready to use any means they can to get it. Now, I pointed out at the start that Machiavelli didn't actually use that phrase. It's very important to know that Machiavelli's philosophy was very rooted in a tradition of morality, of moral philosophy. And so this father of modern political science, the real question for him would have been, what about the end does justify the means? And for that type of philosophy, it very much needed to be a moral outcome. That's what's been missing in Susan Nechles' cross-examination. That's what has been missing and lost in this country right now. And that's never been made clearer than by the behavior of today's Republican Party and the powerful leaders who support Trump and all of the people who try to enrich themselves at any cost, at any expense. Just take a look at the fact that there are now a sitting member of Congress came to court today to sit there to support Trump, and then afterwards basically speaks for Trump, putting down, insulting, questioning the judge and the judge's daughter. That is the problem right now. That's the morality that's been lost. So thanks for listening. Keep those comments coming. It's very helpful to get those, and look to talk to you soon.
Love this video? Make sure you stay up to date on the latest breaking news and all things Meidas by signing up to the MeidasTouch newsletter at MeidasTouch.com/newsletter.